Hi everyone, my name is Rebecca. I'm a claims specialist here with the Industrial Commission. Thank you for joining me today for the Claims Adjusting Part 3 webinar training. Today we will be discussing request to change doctors, request to leave the state, suspension and reinstatement of benefits, guardian ad litem, and cease and desist process for injuries sustained by a minor. Well, let's jump right in, starting with request to change doctors. Here's a request to change doctor form. The form is available on our website. Any interested party can request a change of physician, but the most common party to request a change is the injured worker or their representative. The carrier can request a change of doctors under ARS 23-1062.02. The adjuster can approve a change without getting the ICA involved. For example, if their current treating physician refers them out to a specialist, or if they believe a doctor is more qualified to treat them, that isn't something that needs to come through the ICA. But I would recommend, if the injured worker is requesting to go to the same type of doctor, or a doctor that wasn't referred by the current doctor, to have them file a request to change doctors with the ICA. That way, if it appears that they are doctor shopping, we'll have a recording of that also. Directing care. Only specific self-insured carriers may direct medical care. We do have a list on our website available through the link shown here. Best practice alert for direct medical employers. You can provide multiple physicians of your choosing without the requirement to see any of them, so the injured worker can retain their ability to choose which doctor they want to see. The ICA change of doctors process. When a request to change doctors is received, a claims specialist like myself will contact the adjuster for their opinions on the change of doctors request. An adjuster must have a legitimate reason to disagree with the change. For example, I don't care for that doctor, or I'm planning to set up an IME eventually, is not a legitimate reason to deny a request. If they're downgrading care, like they broke their leg in 3 places and they're seeing a surgeon, but they want to see a chiropractor, that would be a legitimate reason to deny the request. Or if the ICA has record of doctor shopping, if the ICA doesn't have record of doctor shopping, we cannot deny the change for that reason. Unless it is an employer who can direct medical care, the approval or denial is in the discretion of the ICA. Here is a findings and award regarding change of doctors. All interested parties are sent a copy of this award: the injured worker, the employer, carrier, any attorneys on record, and both the doctors. The request is effective the day the award is issued. If you disagree with the approval, a request for hearing can be filed to protest within 10 days from the date of the award. Finding an award for a change of doctors that is denied. This also has a 10-day protest period from the date of the award. All right, moving on to leave the state requests. When does an injured worker need to request to leave the state? A request to leave the state is required if the injured worker is going to be out of the state exceeding more than 14 days. So if they're returning on the 14th day, a request to leave the state is not necessary. Only when they're going to be out of the state 15 days or more. If they wish to reside in a state other than Arizona, then a request to leave the state is required. If an injured worker already resided in another state other than Arizona when the injury occurred, a request to leave the state is not required. Closed claims or claims under supportive care do not need to request to leave the state. A request to change doctors may be required if they plan to continue their supportive care in the state they are now residing. The ICA process for leave the state. A claims specialist will contact the adjuster for their opinion on their request to leave the state. Again, a legitimate reason is required if you wish to disagree. I don't want them to leave the state isn't a legitimate reason to deny a request to leave the state. A legitimate reason could be they just had surgery 3 days ago and the doctor has them on restriction and they aren't supposed to be traveling. Finding and awards regarding leave the state. This is the approval. The finding and award is effective from the date filed or the date of leaving. If they filed a request to leave in advance, it will be effective on the day of their departure. If they file a request after they have already left the state, it is effective from the date they filed the request. When a leave the state request is approved to reside in another state and they plan to continue treatment in a different state, a request to change doctors is not required. There is also a 10-day protest period on the approval or denial of the award. Next up is suspension of benefits. This is a notice of suspension of benefits, or 105. There are only 4 reasons under Arizona statute that will allow you to suspend an injured worker's benefits. Those 4 reasons are they left the state without written approval from the ICA, and that's under ARS 23-1071A. If they refuse to submit or obstruct a medical exam, if an IME was scheduled and they didn't show up for the appointment, that would be a reason to suspend their benefits. That is under ARS 23-1026A, B, and C. If they failed to submit an annual report of income, or if they're incarcerated. Best practice alert, Rule 118 applies, and retroactive suspension more than 30 days required, good cause. Incarceration. Benefits can only be suspended if they have been convicted or pled guilty of a crime and are now in a state, federal, county, city jail, or correctional facility. All compensation benefits are suspended during incarceration. Medical benefits continue, and any court-ordered child support payments are to be paid pursuant to ARS 23-1031B. Motion to suspend benefits. Under legal representation, a carrier can apply to suspend benefits under ARS 23-1026E or 1027A with a motion to suspend benefits. The statute ARS 23-1026E states the Commission may reduce or suspend the compensation of an injured worker who persists in unsanitary or injurious practices, or who refuses to medical or surgical treatment necessary to promote recovery. Statute ARS 23-1027 states if an injured worker unreasonable refusal or neglect to submit to medical or surgical treatment resulted in their death or disability, no comp will be paid. Reinstating benefits. When the injured worker complies with the provisions of the suspension, the benefits may be reinstated. To reinstate benefits, a notice of claim status must be filed, marking box number 11 and indicating that benefits are being reinstated and including an effective date. Guardian Ad Litem. Guardian Ad Litem Incompetent Person. Under ARS 23-1066, provides the appointment by the ICA, a guardian ad litem, for an incompetent person. Medical evidence of this person's incompetency is required. Just being uncomfortable talking with us, or they'd rather have somebody else deal with it, is not an eligible reason to file for a guardian ad litem. Guardian ad litem for a minor. Under ARS 23-1066, allows for the appointment by the ICA of a guardian ad litem for a minor. A minor is under age 18 and have sustained a temporary disability or permanent impairment. The guardian ad litem for a minor must be under the age of 18 and have sustained a temporary disability or permanent impairment. Consent to act as a guardian may be obtained by the carrier and forwarded to the ICA for issuance of the formal appointment. A guardian must be appointed prior to the minor's involvement in litigation. This is a finding and awards for appointment of guardian ad litem. There's a 10-day protest period on this award. If a request for hearing is not filed within the 10-day protest period, the award will be final. And last but not least, the minor labor violation cease and desist order. The Department of Labor investigates all workers' compensation claims filed by a minor. They investigate whether or not the minor was engaged in an occupation or performing duties not legally permitted to as a minor. If found that they were performing duties illegally, a cease and desist order will be issued by the Department of Labor. When the order becomes final, the Claims Division will send a copy of the cease and desist order to the carrier with a letter advising them to pay the minor injured worker an additional 50% compensation. All comp is paid at a rate of 150%, or time and a half. The additional compensation is recovered from the employer. The cease and desist process. The process of the adjuster is to recalculate all compensation paid in the past and going forward to include the extra 50% owed. This applies to temporary disability and permanent disability payments. The statute allows recovery against the employer for the additional 50% that has been paid. The ICA will send a letter to the carrier confirming the award when final. The Claims Department number is provided for you on the screen. Please don't hesitate to call for assistance. Thank you all again for joining me today for the Claims Adjusting Part 3 webinar training. Bye now.